Good morning. Today, my friend Nelson has come asking about how bail applications should be filed and how it has to be argued in the concerned courts. First of all, I would like to say that when a client engages or when a matters come to you, you have to see whether what are the offences given on the accused. These offences, whether they are bailable or non-bailable, has to seen in the schedule of the Criminal Act book, say the CRPC and other thing. Second thing is whether these offences are triable by magistrate or sessions court offence. If it is triable by magistrate, you have to file a bail application in the concerned magistrate court where the concerned jurisdiction, police jurisdiction arises. Or if the offences are triable by sessions, Your Honor, even if it is one offence is triable by sessions court, the application has to be filed before the concerned district court. Second thing is, Your Honor, whether these offences are bailable or non-bailable. If it is a bailable offence, you can file it in the concerned magistrate court, get the bail on the same day. If it is a non-bailable offence, you have to file the bail application. The notice will be served upon the police and they have to give a reply when the magistrate gives the date for bail application. If suppose there is an you don't get the reply as early as possible, or if the concerned police seeks for an adjournment, or if the reply is getting delayed, you can very well argue your facts of the case before the magistrate, stating that there need not be any further adjournment given, since because the offences are very light in nature. Say for example, if the injury caused is very much less or is of less of seriousness, you can ask for bail immediately. Or if the injuries are serious in nature, you yourself can assess the damage and you need not press the presiding officer for bail immediately, stating that the injuries are serious in nature. You can decide the bail as the nature of the offences are involved. The seriousness of the offences are to be also to taken into account. If these things are read and being argued before the concerned court, bail will be granted. Most of the persons, or say the so-called advocates, they don't read the FIR, they don't read the remand report, they have to read the entire details in the case and come forward with an application stating all these facts, Your Honor. Nowadays, you can see the application doesn't tell anything about particulars or about the facts of the case, or at least what is the case of the defense or the accused. They straightaway file the remand date and offences. There will be no whisper about the prosecution case or the defense case. In such cases, at least if they don't mention all these things, they should orally submit before the concerned court requesting for a bail. But nowadays, these things are lacking. This has to be developed. Unless you say the facts of the case, the officer concerned will not get satisfied. You have to impress in such a way that the bail is granted to you, even if though the prosecutor opposes or the assistant prosecutor opposes the bail, your submission should get over and you have to get a bail. Until then, only then your power shall be, your strength shall be proved there, and you will get a good name with your clients. So all these things plays a vital role in filing bail application. Moreover, the bail applications should have all the details of the accused and what defense he has taken, or what is the defense you are going to say to the court. It has to be neatly produced and it has to be produced at the earliest point of time, so that even if your bail application is getting dismissed on the first time, the second time the concerned presiding officer will have a remembrance over your case and grant bail at the earliest as possible. This is a small advice that read the FIR, read the materials in the court, dictate all those things in your bail applications in a neat and legible manner, say all these things in the as oral arguments in the court, get the bail as early as possible, do best to your clients. At the same time, you have to see that the complainant doesn't get affected by these also. You have to balance, because you are having doing a noble profession. You have to balance the society. You have to mainly convince your client that it is a case of murder. The bail will take a little longer, and you don't give any false assurance to your client. This is my advice. Nowadays, the young advocates are not doing or not following this. So kindly advise your client. You are at a top priority in the society. You have to give a good suggestions and good advice to your clients. Thank you.